In this video lecture, we will talk about legal liability and malpractice. This is a topic that every professional, including behavioral health professionals, need to understand so that they can avoid being sued. Or in the alternative, to better understand when it might be advantageous for them to sue someone else. So what is legal liability? Well, it's the legal responsibility for one's acts or omissions. Failure of a person or entity to meet that responsibility leaves him or her or it open to a lawsuit for an appropriate remedy. Everyone, including professionals, need to take responsibility for what they do or don't do. Now, there are a number of types of potential legal liability. First, there's contractual liability. This occurs when there's a contract or an agreement between two people. A person can be contractually liable if you agree to do something or promised something and didn't come through on it. You could be held liable according to the terms of the contract. Another type of legal liability is products liability. You may hear about this most often in the car or tire industry, where someone has sued a car company because of failure of the product. In the healthcare industry, if you provide a product like oxygen, you'd better make sure that it's good oxygen, or you could be held liable for the poor product you're providing. Finally, there's an area of legal liability called torts. Now, this isn't just a delicious pastry. What a tort is a, quote, wrong, an injury resulting from a breach of duty that exists by virtue of society's expectations regarding personal conduct, unquote. So it's not a contract or other personal relation. It's based upon our society's expectations of how we should behave. Then someone doesn't live up to those expectations and ends up injuring someone else. That's a tort. Another way of describing it is that someone does not exercise the care that a reasonable person would under the circumstances, or does something a reasonable person would not do under the circumstances. Now, there are a couple kinds of torts as well. The first are intentional torts. These include things like false imprisonment. If someone locks you in a closet or stops you from leaving a confined space, they could be found liable for false imprisonment. Another example of an intentional tort is defamation. Defamation is where someone says, writes, or does something that inappropriately disparages the reputation or character of another person. Written defamation is called libel, and spoken defamation is called slander. The second kind of tort is negligence. Negligence encompasses several other types of liability and applies to a much broader array of situations. Negligence is also the basis for most professional liability and malpractice claims, and it is what we're going to talk about for the remainder of this video lecture. There are four elements that must be proven to have a successful case of negligence against another person. That is, the plaintiff, or the person who initiates a lawsuit, must prove four things in order to successfully sue a defendant or a person who's accused of wrongdoing. Those four elements are duty, breach, cause, and damages, sometimes called injury. These four elements are easy to remember by considering that it is not ABCD, but DBCD, representing the first letter for each of the elements. Let's discuss each of these in more detail. The first element is duty. That involves proving that the defendant owed a duty to the plaintiff to behave up to a particular standard. So what is meant by duty? In general, you need some kind of relationship to have a duty. Relationships like the case manager and a client, or a store owner and a customer, or a doctor and a patient. People who have such relationships may have certain duties to behave in a particular way towards each other. However, courts have also extended duty to include any foreseeable plaintiff at the time of the negligent act. So, for example, a store owner could foresee that a person could trip and fall over a dangerous obstacle in their store. They don't need to know who the person is, but that they could foresee someone getting injured. So, they are a foreseeable plaintiff. Likewise, a distant relative who is traumatized by your poor care of their loved one could be considered a foreseeable plaintiff if you negligently care for a client. It is foreseeable that a relative might sue you for damages, even though at the time you had never met them. Some courts have defined foreseeable plaintiffs as just about everyone. So the bottom line is, don't be negligent, or just about anyone could potentially sue you. This is why we have professional liability insurance. So say you have a duty. To what standard of care must you carry out that duty? The general standard of care is whatever an ordinary, reasonable, prudent person would do in like circumstances. So you would behave as an ordinary, reasonable, prudent person, or an ORP. Now, in some contexts, the standard can be refined more. For example, a nurse should behave as any ordinary, reasonable, prudent nurse would in like circumstances. Or a psychologist may be held to the standard of an ordinary, reasonable, prudent psychologist. But as I said, the general standard is what an ordinary, reasonable, prudent person would do. So let's consider some examples. Say some motor oil is spilled on the floor of a supermarket. What would an ORP do? An ORP would likely clean up the motor oil as soon as he or she could to make sure someone doesn't slip and hurt themselves. What if an apartment complex owner decides to not put a light in a dark area of their parking lot? Is that what an ORP would do? That would depend on how dangerous the situation is. I bet you haven't seen many parking lots without lights, though. So the standard seems to be to make sure parking lots are well lit. What if an apartment complex owner decides not to install a manned gate at the apartment entrance? Again, it depends on the circumstances. If the apartment complex is in a fairly high crime area, perhaps a manned gate is what an ORP would do. On the other hand, if crime is low, or if the complex is in a rural area, such security may not be necessary. What an ORP would do depends upon the context of the decision. The second element that needs to be shown is breach of the duty. That is, did the defendant meet the standard of care, or was the duty owed violated by the alleged liable person? Some examples that we just reviewed could be a breach of duty. For example, say the supermarket manager decides not to clean up the motor oil for 3 days. That would be considered a breach of the manager's duty to his customers. Likewise, not installing a light in a dark area of a parking lot where crimes have occurred with some frequency could be considered a breach of the duty owed to the people who use the parking lot. In other words, it is not what an ORP would do. I'm going to skip over the third element right now and talk about the fourth element, that is damages or injury. The issue here is whether someone got injured physically, mentally, or financially. So if you go to your car with no problem in a dark parking lot and drive away, even though there may be a duty to light the lot and that duty is breached, you have no claim unless you are injured. There are two types of damages that a person can be liable for. These are what the defendant would need to pay for if he or she is found negligent. The first type of damages is compensatory damages. These are damages designed to repay the plaintiff for his or her loss due to the injury incurred. For example, if someone is injured and they can't work for 6 months, some of the compensatory damages awarded could be the salary that they would have made had they been able to work. Compensatory damages can also be awarded for emotional distress. So if someone becomes excessively anxious or experiences post-traumatic stress because of the injury incurred, the court could order the defendant to compensate the plaintiff for their emotional distress. Almost anything that you can imagine has a dollar value associated with it. For example, the loss of an arm might be worth $1 million to a manager in a McDonald's. However, loss of an arm may be worth many more millions of dollars to a pitcher of a Major League Baseball team. The court takes into account the specific context of the injury in calculating what the compensatory damages are. The second kind of damages that can be awarded are punitive damages. Punitive damages are designed to punish the defendant for recklessness and are awarded on top of compensatory damages. Punitive damages oftentimes come into play when, for example, a large corporation is negligent and the court wants to send a message to that corporation. And just awarding compensatory damages will not send the message that the procedures need to change. An example used in the news quite a bit is the McDonald's hot coffee example. A woman purchased McDonald's coffee in the drive-thru lane and took the coffee and drove off with it held between her legs. The coffee spilled on her and gave her severe burns in a very sensitive area. She sued McDonald's, claiming that their coffee was just too hot. And indeed, McDonald's did keep their coffee 15 to 20 degrees hotter than any other coffee vendors. McDonald's claimed that their customers liked hotter coffee because it stayed hot longer. McDonald's was found liable for the injuries to the woman, and the court went beyond compensatory damages and awarded millions of dollars in punitive damages with the idea that McDonald's should change their processes. Again, punitive damages can be awarded to punish a defendant when the defendant has been reckless. Let's go back to the third element that needs to be proven to have a successful negligence case. The third element is cause. That is, did the breach in duty actually cause the damage or injury? In assessing this element, the court considers the foreseeability of the chain of events that caused damages. In other words, was it reasonably foreseeable that not cleaning up the motor oil, for example, could cause an injury to occur for somebody? Sometimes the courts find cause when there are some pretty remote chains of events that occur. Kind of a series of events that occur in the mousetrap game, for those of you who are familiar with that, or a Rube Goldberg type chain of events. In general, though, the relationship between the breach in duty and the damages is pretty direct. Let's consider some examples. If you were to get into your car in a dark parking lot, drive 2 blocks, and get into an accident, is the parking lot owner liable? Well, there may have been a breach of duty and damages, but it is unlikely that the breach in duty actually caused the damages or the injury, unless you were so upset about the dark parking lot that it caused lingering distraction in you. Likewise, if someone were to trip on an obstacle in a store and then 2 weeks later developed a brain tumor, there may have been a breach of duty and harm or damages, but there really was no causation there. If any of you go to law school, you'll spend many weeks discussing proximate cause, which is another concept when considering this element of negligence. Proximate cause is the idea that when a plaintiff is injured as a result of negligent conduct, the plaintiff's injury must have been a natural and probable result of the negligent conduct. Many accidents have more than one proximate cause, and it's not necessary that the defendant's negligence be either the only proximate cause of the injury or the last proximate cause. A defendant may be liable even where injury has multiple proximate causes, regardless of those causes occurring at the same time or in combination. For example, consider a plaintiff driving down a road. He is suddenly cut off by a person who runs through a stop sign. The plaintiff slams on his brakes and is able to avoid hitting that car. However, the plaintiff is rear-ended by another driver who was not paying attention. In this case, the plaintiff can bring an action against both drivers, and the court can determine the extent of liability of each of the negligent drivers. So how can the defendant respond to the plaintiff's claim of negligence against them? Well, there are a number of defenses to a negligence claim. First, the defendant could show that one of the 4 elements of negligence is not met. They could show that they don't owe a duty, or that the duty was not breached, or that the breach in duty didn't cause injury, or that there were no injuries to begin with. Another way to defend against a negligence claim is to assert that the statute of limitations has expired. The statute of limitations is a legal requirement that an action or lawsuit must be brought within a certain amount of time. Otherwise, it would be unfair to a defendant trying to respond to the lawsuit. For example, the statute of limitations for contract actions is 6 years. So a liability claim under a breach of contract must be made within 6 years of identifying the breach. For negligence claims, the statute of limitations is 2 years in most states, including Florida. So a plaintiff would need to sue a defendant for negligence within 2 years of the discovery of the injury. Now, statutes of limitations can be tolled, that's T-O-L-L-E-D, tolled or suspended for a variety of reasons. For example, if the injury was not apparent for many years, the statute of limitations would be tolled or suspended until the injury was discovered. Then on the date when the injury was discovered, the clock would start running on the statute of limitations. Another defense against negligence claims is contributory negligence. Most states no longer use this concept. However, it is still used in some areas. Contributory negligence reflects the idea that if the plaintiff, in other words, the person suing for damages, contributed at all to the injury, the claim is nullified. So if the plaintiff is at all responsible for even a small part of the injury, they cannot bring a claim. In other words, they need to have clean hands coming into the lawsuit. Because this was considered kind of harsh towards plaintiffs, the concept of comparative negligence developed. With comparative negligence, which is used in most states, the relative proportions of responsibility are determined by the court. So if the defendant is 60% responsible for the injury and the plaintiff is 40% responsible for the injury, the court would determine what the overall award amount would be for the negligence, and then the defendant would only be responsible for 60% of that amount. So for example, in the McDonald's hot coffee case, although McDonald's was negligent in superheating the coffee, the defendant was partially responsible for her injury because she put the cup of hot coffee between her legs in a moving car. Her compensatory damages were reduced based upon that calculation. The final defense to a negligence claim that I'm going to talk about here is assumption of risk. Assumption of risk is essentially an informed consent issue. If a person assumes the risk or waives their right to sue if they are injured, then that can be used as a defense if the person turns around and sues, because they essentially assumed the risk of the injury. So for example, if you go skydiving, the skydiving company will have you sign a waiver of liability. What that means is that you recognize the dangers of skydiving, and if you get injured while you're skydiving, you assume the risk of it and will not hold the skydiving company responsible. The waiver of liability, however, only protects a defendant if they act in a reasonable, non-reckless way. So for example, if you sign a skydiving waiver and the skydiving company forgets to competently pack a parachute in your backpack and you get injured in the process, you can overcome the waiver of liability because the defendant may have acted recklessly. You can also never assume the risk of death. So if negligence results in death, assumption of risk does not typically apply. I'd like to briefly discuss two other concepts related to negligence. The first is gross negligence. Gross negligence means conduct or failure to act that is so reckless that it demonstrates a substantial lack of concern for whether an injury will result. It is sometimes necessary to establish gross negligence as opposed to ordinary negligence in order to overcome a legal impediment to a lawsuit. For example, a government employee who was on the job may be immune from liability under the principle of sovereign immunity for ordinary negligence, but may remain liable for gross negligence. Similarly, as I alluded to when we were discussing assumption of risk, if a plaintiff signs a release before doing some dangerous activity, for public policy reasons, many jurisdictions will apply the release only to conduct which constitutes ordinary negligence and not an act of gross negligence or recklessness. The reason for this is quite simple. It's not good public policy to allow a defendant to escape liability for reckless indifference to the safety of others, particularly in contexts where the defendant is responsible for creating unsafe conditions or is profiting from their existence. The second concept related to negligence is vicarious liability. Vicarious liability occurs when one person is held responsible for the negligence of another person. Typically, this applies in the employment context, where the employer is responsible for the negligent acts of the employee, which occur within the context of the employment relationship. For example, an employer may be liable for an accident caused by an employee as the result of a negligent operation of a delivery vehicle. Another context where vicarious liability might occur is with the parent-child relationship. Parents may be held vicariously liable for the negligent acts of their children. However, many jurisdictions have limited the vicarious liability of parents, and some have even eliminated it. This is in recognition that parents do not always have control over their children. So that's negligence. With all the potential liability we have just talked about, how can you protect yourself? None of us is ever free of potential liability, and that's why we have insurance. But the key is to just act as a reasonably prudent person would in what at times can be fairly difficult situations in behavioral health care, or whatever professional role you choose to take on. If you're unsure whether you're being an ORP, talk with colleagues and document your thinking. Most people will never be in court defending a liability claim, but if you are, letting the court see that the decisions you made were thoughtful and reasoned can be very helpful in your defense. Okay, let's apply the concepts of negligence that we've just discussed by analyzing a case vignette. Betty Bone is driving through a residential neighborhood at the posted speed limit of 25 miles per hour. She's not paying close attention to her driving. She's humming along to the radio and putting on her lipstick using her rearview mirror. While she is thus distracted, a child's ball rolls out from between two parked cars on the right side of the street. Betty does not see the ball. A few seconds later, Joey Webb, aged 8, dashes out to retrieve the ball. Betty is unable to stop and collides in a glancing blow with Joey's arm. Joey falls down, clutching his arm and yelling. Betty stops her car, rushes out to help, and realizes Joey's arm is hurt. It turns out to be a hairline fracture. Betty calls an ambulance using her cell phone. So does Betty Bone owe a duty to Joey Webb, the 8-year-old? Indeed she does. As the driver of a car, she has a duty to pay attention and to avoid causing injury to others around her car while it is in motion. Was there a breach of that duty? Yeah, there was a breach of duty. She was not paying attention and ended up hitting Joey. Did the breach cause injury? Yeah, her inattentiveness caused injury to Joey. Are there any defenses that she might be able to raise? At best, she could raise the comparative negligence defense that is claiming that Joey was partially responsible for his injury, but it wouldn't be strong. In these kinds of cases, her inattentiveness was the primary cause of an injury to a child who she should have foreseen might be playing on the street. Let's now add in a couple of case twists. Here are some new facts. The driver is now judge upright. He is also not paying close attention, but since Joey dashes out from between parked cars immediately in front of the driver, a passenger, Sister Mary Margaret, exclaims that there was no way the judge could have avoided Joey. In this instance, did the breach of duty cause the injury? It would seem so. But while there was a breach of duty, there is a legal principle that suggests that the breach was not the thing that caused the injury. If something is completely unavoidable, and it did not matter what the person driving the car did, then the driver can argue that his or her actions did not cause the injury. Rather, it was almost an act of God. So in this case, Judge Upright, emphasizing the testimony of his passenger, Sister Mary Margaret, could argue that the injury was unavoidable because of the circumstances surrounding how it happened. This doesn't mean that he will win, but he certainly can make the argument. Let's consider a different scenario. The driver is now Carla Careful. She's paying close attention, but Joey drops out of a tree above her. Carla's only warning is Joey's friends on the sidewalk gesturing up at the tree and singing the Spider-Man song. You know, Spider-Man, Spider-Man does whatever a spider can, that sort of song. In this case, is there a breach of duty? Maybe, but maybe not. Carla Careful could certainly argue that she was driving as safe as she possibly could. Nevertheless, assuming that there was a breach of duty, was Carla the proximate cause of the injury? She could certainly argue that she was not the cause of the injury. Not only was the injury unavoidable, but she could not have possibly foreseen a child falling from a tree above her, even though the children were singing the Spider-Man song. The question for the court would be whether it is reasonable to hold her responsible when she A, could not avoid hitting the child, and B, could not have foreseen a child falling from the sky. Realistically, however, her auto insurance could very well cover the cost of the injury of the child anyway. That concludes this video lecture on legal liability and malpractice. Hopefully you can take away some key concepts that will help you to avoid or defend against lawsuits in your professional career.